Hello, everybody. Today we're going to start Unit 6, which is the judicial branch. In this initial slide, you can see the upside down triangle that we always call federalism. Remember, each one of our branches is divided into three different levels, and that's federal court, state court, and local court. In the United States, we have three different levels of judges, which we'll talk about here in just a little bit. But first, we're going to talk about their qualifications. For United States judges, they don't actually have any qualifications other than the stipulation that they have to be appointed by the president and approved by the Senate. So, what that means is that any one of us, any citizen of the United States or not citizen of the United States, could be appointed as a judge on the federal level. But remember that everything has to get approved through the Senate. There is this one other little thing called senatorial courtesy, which means that the president will ask the opinion of senators from the judge's home state. So let's say that President Trump were to appoint me, Coach McCray, to a federal judgeship. He would ask Tom Tillis and Richard Burr, who are our senators, if I could be approved or not. And if they approve me, then the other 98 senators would agree to approve me. Moving on to North Carolina judges. North Carolina judges do have qualifications, much like every other position in North Carolina. First, they have to be 21 years old. They have to be a registered voter, able to practice law, meaning they have had to gone to law school and pass the bar exam. They must live in their district, and they are elected by the people, and they serve an 8-year term limit. But there are no actual limits to the amount of times that they can be judged. Here are benefits of a federal judge. They get to serve for life, and they cannot have a pay cut. But if they break the law, very much like the president, they can be impeached by the Congress or by the legislative branch in the same way that the president can be. Why is this the case? Well, I want y'all to think about this. Judges make very, very difficult decisions on a daily basis. And so, to avoid outside influence from the media, from politics, from people, they have their judgeship protected so that they are able to make those hard decisions. We have to talk about a couple things as far as jurisdiction goes. And what jurisdiction is the authority to give orders in a certain area. So obviously, this federalism would apply to jurisdiction. And there are four different types of jurisdiction that are grouped into two different categories. And I'll try and explain those to you as best as I can. The two types that we're going to talk about today are original and appellate jurisdiction. Original jurisdiction is when a court has the authority to hear a case for the first time. So if you were to break a law, this would be the court that hears your case. But after that case or after that court has made a ruling on your case, you can appeal their decision to a higher court, and that would give appellate jurisdiction. So, in appellate jurisdiction, the court has the authority to review the case to make sure that the law was applied fairly. And they typically look at the Constitution to see if the law was applied fairly. So we're going to talk about how many courts are set up in the Constitution. If you look, it says the judicial power of the United States shall be vested in one Supreme Court, and such inferior courts as the Congress may from time to time ordain and establish. So the answer to how many courts are set up by the Constitution is just one. And so the Supreme Court was the original court that was set up by the Constitution. However, Congress has established many more courts in the past 220 or so years. And so, what does it say about judges? It says, the judges both of the supreme and inferior courts shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So basically, that just goes back to what we were talking about as far as judges cannot be fired for their decisions and their pay cannot be cut. So Congress, after the Supreme Court was created, passed the Judiciary Act, and the questions here say how many SCOTUS judges are there. Remember, SCOTUS stands for the Supreme Court of the United States, and so in the Judiciary Act it says that the Supreme Court of the United States shall consist of a Chief Justice and 5 Associate Justices, any 4 of whom shall be a quorum. So that's 1 Supreme Court Justice, or 1 Chief Justice and 5 Associate Justices, for a grand total of 6 Justices. A quorum is a majority to be able to hold court. And so essentially that just means like you can't go to the Supreme Court and there's only 2 justices there that day and they decide your fate. The United States shall be, and they hereby are divided into 13 districts. So that answers question number 2. How many district courts are there and judges? So there are 13 districts. That there be a court called the district court in each of the aforementioned districts, to consist of 1 judge who shall reside in the district for which he is appointed, and shall be called a district judge. So originally there was only 1 district court per state, and there was only 1 district judge per court. Moving on to the federal court and the SAD cake. We call it a SAD cake because it is an acronym for Supreme Appellate and District, which we also have special courts that we'll get to in just a second. At the bottom, the lowest level, is the district court. District court has original jurisdiction for all federal cases. There are 94 total, with at least 1 per state. Most states have more than 1, but you have smaller states with smaller populations that only have 1. There are cases heard by the judge and the jury. So this is what you would think about in a normal court case. There's 1 judge. There's 12 jury members. 90% of all federal cases start here, and it is the only federal court that hears cases and reaches verdicts, which means guilty and not guilty. So district court is really just your very, very basic court that you like to think about. The people involved are a marshal, the grand jury. Remember, the grand jury does not actually appear in court. You don't see them. They are the people to determine whether or not there is evidence to try a case. And remember, there's a grand jury only in federal cases, not in state cases. There is a district attorney who is in charge of prosecuting people. There is a public attorney who is the person guaranteed to you through your 6th Amendment to defend you. There is a judge who will issue a sentence but not come to a verdict, because the jury decides whether you are guilty or innocent, or they don't typically say innocent, they typically say not guilty, because the court doesn't like to admit that you were innocent unless you actually are. They just like to admit that they couldn't prove that you were actually guilty. There are 6 different types of special courts. You have the Military Court of Appeals for soldiers who break laws, Tax Court, the Court of International Trade, the Court of Federal Claims, Land Claims, and Bankruptcy Court. I'm not going to spend a lot of time on these because they're not as important as the other types of courts that we're going to talk about. Then you have appeals court. Appeals courts are also known as appellate courts, circuit courts, or the Court of Appeals. And they have appellate jurisdiction only. A case will never, ever, ever start in appellate court. In an appeal, when you appeal, the lawyer thinks that the law was not applied correctly in your original verdict, and therefore they appeal to have your verdict overturned. In an appellate court, there are 3 judges and no jury, and they can only overturn your verdict, which means you go from being guilty to not guilty. They can deny to hear your case, which means they think the law was applied fairly. Or they can remand your case, which means there was something a little off in the first trial, and so they just fix that and send it back to a lower court for a new trial. So, for instance, if you weren't given a lawyer in your first trial as guaranteed by your 6th Amendment, then instead of just saying, no, you're not guilty, they would just give you a lawyer and let you retry your case. There are 12 total circuits, because there is 1 circuit in Washington, D.C. that is not listed on this map. North Carolina is in the 4th circuit, and the circuit that contains the most states is Circuit 9 with 1, 2, 3, 4, 5, 6, 7, 8, 9 states, plus Guam and the Philippines. So it serves 9 states and 2 territories. And then we move on to the Supreme Court. Remember, the Supreme Court is also known as the SCOTUS. We're going to skip through these. So in the SCOTUS, there is one Chief Justice and now 8 Associate Justices, for a grand total of 9 Justices. Remember, Justices are appointed by the President and approved by the Senate, and they have original and appellate jurisdiction, but typically they only exercise their appellate jurisdiction. The only 2 times that the Supreme Court has original jurisdiction is when a foreign diplomat is involved, or when a case is involved with 2 different states. The Supreme Court only has appellate jurisdiction when there has been a constitutional issue. So when one of the amendments or articles was violated when applying to your case. Here is a picture of the current Supreme Court. I'm not going to go through the time and list them all. This is the Supreme Court located in Washington, D.C. It looks very similar to the U.S. Capitol building and the White House. Alright guys, that is all I have for you today. Please make sure that you took notes and answer the questions in the PlayPosit. I hope you guys have a great day, and I hope to see you all very soon.